Assalamualaikum. My name is Muhammad Hadi Aris bin Saufi. My matric number is 061673. Today, I will be reviewing case about Guan and New Straits Time Press, Malaysia Berhad. This is a defamation case brought by the plaintiff against Dato Dr. Syed Hussein Maidin, the head of the UMNO Youth Wing in Penang. On the day of the trial, they had resolved their difference and recorded the consent judgment. During the proceedings, a journalist who is defendant employee of the Daily News was given a copy of the permit draw judgment. The defendants printed and published an article in Berita Harian newspaper on August 20, 2015 titled Guan Withdraw Action Against Former State UMNO Youth Chief. In short, the news article claims that the plaintiff has not pursued the civil action he filed against Dato Dr. Syed Hussein Maidin, who slander and denigrate him in his office, position and profession, and that his termination was made unconditionally on the first day of the trial. Plaintiff claimed that the statement in question is defamatory against him and does not constitute a fair and accurate report of the judicial proceeding in the High Court. The plaintiff sought an order requiring the defendant to print and publish an unconditional apology to the plaintiff within 7 days of the judgment in a prominent section of the Berita Harian Daily, in accordance with the judicial power of this Honourable Court under Section 53 of the Specific Relief Act 1950 and its inherent jurisdiction. The plaintiff openly and tactfully admit that the Dato Dr. Syed Hussein Maidin defamatory allegations, the core of which is an allegation of bribery against the plaintiff in his role as the Chief Minister of Penang, are true and justifiable. The plaintiff admits that Dato Dr. Syed Hussein Maidin was justified in making those defamatory statements, namely that the plaintiff lacks integrity and self-respect, is unworthy of reputation and credibility, and has a character that is devoid of integrity and honesty, and is unworthy of the position and office he holds. The defendant offered to print an erratum in Berita Harian, but the plaintiff refused and insists on using their phrasing. On December 18, 2015, the defendant published an erratum in Berita Harian. Despite the erratum publishing, the plaintiff filed the action in these cases. The issue is whether the impound statement in the news article published by the defendant in Berita Harian on 20 August 2015 are defamatory of the plaintiff. Second, if the answer to the above is affirmative, whether the publication of the impound statement gives rise to connotation and or imputation enumerated in paragraph 23 of the statement of the claim. 3. Whether the defendant can rely on the defense of qualified privilege. 4. Whether the defendant can rely on the defense in Section 12 of the Defamation Act 1957. 5th, whether the defendant can rely on the defense of reportage. 6. Whether the defendant can rely on the publication of the ralat in mitigation or extension of damage. 7. Whether the plaintiff is entitled to be awarded of the relief and order as prior. The plaintiff action was granted with cost of 35,000 ringgit by the High Court. This is because the challenge claim based on the evidence did not constitute a fair and accurate representation of the judicial proceeding and were incorrect and deceptive as fact had been perverted to the point that the article was reduced to false news. Malice on the part of the defendant could be inferred in such case. Furthermore, a reasonable person will view the entire case negatively by dismissing the civil complaint unconditionally because the plaintiff had acknowledged the serious charge of bribery. The contested comment had the potential to carry negative implication and or imputation against the plaintiff, leaving a bad impression in the mind of a reasonable reader. The contested comment obviously have the potential to incite resentment toward the plaintiff, and the negative view of others tend to diminish the plaintiff's standing among society right-thinking citizens. There was no doubt the plaintiff's name was plainly indicated in the news article containing the impound statement, and so the impound statement pertained to the plaintiff. In addition, the defendant admitted in his defense that impound words were contained in a news piece published in the Berita Harian Daily. As a result, the contested assertion were made public to third parties. The complainant could not have been of great social status. The libelous claim of the receiving bribe was grave and serious in nature with the potential to harm the plaintiff's reputation as Chief Minister. Furthermore, the Berita Harian Daily had a large distribution in Peninsular Malaysia and published a large amount of material. The court ordered RM300,000 in general and aggravated the damage within 5% interest from the date of judgment till realization based on the circumstances. The claim for exemplary damage was dismissed by the court because it did not follow the ground laid for the case Rook and Barnett and others in 1946. The court refused to grant the injunction and apology because it determined that general damage will suffice. So in my opinion, after careful consideration of the judgment of the High Court and the argument of the parties, it is my respectful opinion that the court decision cannot be upheld for a number of reasons. For the sake of clarity, I will attempt to discuss the reasons in broad stroke and then relate them to the contested publication. I believe in this case, the plaintiff filed a defamation suit toward Dato Dr. Syed Hussein Mahdin, who had been the head of youth organization in Penang. They had fixed their conflict on the day of the trial, and the consent judgment was recorded. During the trial, a journalist within the defendant employment for the Berita Harian Daily was there, and the consent judgment was drafted. On August 20, 2015, the title Guan tarik balik saman terhadap bekas Ketua Pemuda Luar Negeri published and posted by defendant in the Berita Harian newspaper in regard to the proceeding. The plaintiff claimed that to him the following sentence were defamatory, that is, Ketua Menteri Guan semalam menarik balik samannya terhadap Ketua UMNO bahagian Dato' Dr. Syed Hussein Mahdin yang menuduhnya menerima rasuah daripada syarikat Kuala Lumpur International Dental Care iaitu KLDIC ketika membina Taman Manggis di sini. In this case, the defendant has a social, moral and legal obligation to write a report of court proceedings information to the public, but the execution of that duty must be to disseminate a fair, relevant, contemporary account of the proceedings. So the impaneled report did not represent a fair and correct statement of the proceeding in the High Court. So in my point of view, the defamatory accusation was serious because he allegedly abused his office by accepting bribe. The libel was of a grave and serious sort. It also tend to ruin the image of the plaintiff as chief minister. Guan was awarded damage due to libel made by the defendant. The defendant were ordered to pay Guan RM300,000 and Justice Datuk Silayok also imposed interest 5% per annum from the date of judgment until the payment fully awarded. Thank you. That's all for me. See you soon.